Friends, may I request all of you who are standing at the back, please take your seat so that we commence our first session proceedings. May I request the organizers to please persuade the participants to take their respective seats so that we can commence our proceedings. Is exclusively dealing with the topic personal guarantor to the corporate debtor. We all know that this journey has started from the year 2019, and there were lots of confusion, lots of litigation. There was one very famous celebrated judgment of the Supreme Court in this matter, Lalit Kumar Jain case. We all know it very well, wherein the matter whether it was through a notification, whether through this notification the definition or the applicability of the act to the different sets of individuals, can it be done through a notification, a sub-delegated legislation? And there were other matters also which the Supreme Court decided in the Lalit Kumar Jain case, but still there are many issues which are yet to be decided. Particularly the one point, guarantor's recourse, the personal guarantor recourse on a recourse to the corporate debtor, whether that matter is still settled by that Lalit Kumar Jain case or matter is still needs, pending in some other case before the Supreme Court. So we have none other than very illustrious speaker whom we have heard in the first session of our today's conclave, say Sandeep Kumar Bajaj. Can I request everyone to give a big round of applause to Mr. Sandeep Kumar Bajaj? He needs no introduction because he has already been introduced to all of us. We have heard him and we know his expertise. So let us utilize his expertise for this session as much as possible. So with this, without any further wastage of time, I will request, because the lunch is awaiting all of us. So it will be a very tough task for you, sir, to keep us awaiting, everyone awaiting for the lunch. But then I'm sure you will be able to do it. So it's over to you, sir.
Thank you very much, sir. I understand I'm the only one left now between you and your lunch. So I'll try to wrap it up as early as possible. Even I don't want to stand, even I'm feeling hungry now. So, okay. So topic which has been given to me, of course, is a jurisprudence on personal guarantor to corporate debtor. Interestingly, it's a big topic, and I'm left with only 15-20 minutes. So I'll have to run fast slides because you all know the provisions. I'll not be dealing with the provisions here. See, a few days back, I was just, maybe we can open the slides, sir. Yeah, sure. So we are. Thank you. Yes. Now we are dealing with the issue of jurisprudence on personal guarantors to corporate debtor. Few days back, I was just going through ICAI recent paper, especially newsletter, and there are interesting facts which came to my attention. Once we see the CIRP process, how many CIRP cases are going on. The total number till date of CIRP cases are 6,571. And out of these 6,571, CD was rescued in 2485 cases, of which 959 have been closed on appeal or review or settled. And 848 have been withdrawn, and 678 cases have ended in approval of resolution plan, while 2030 have ended in liquidation. So once we see this number, we imagine a situation comparing it with the personal insolvency which has been initiated. Out of these CRP cases, FCs have initiated 2,900 cases, OCs have initiated 3,265 cases, and CD corporate debtor itself, of course, in the initial years, there was a lot of zeal among the corporate debtors to take the company into insolvency by filing Section 10 and later on getting the debt restructured, but in view of Section 29A, cases have been reducing since then. And we have seen earlier in the first year itself, there were 111 cases, now only last year it was 70 cases left. So total 6,567 cases initiated in the CIRP. So we imagine a situation where most of the loan by the financial creditors have been given to the personal guarantors, have been given to the corporate debtors by obtaining the personal guarantees. There have been several personal guarantors to one loan itself. So we imagine a situation that when these cases of 2,912 cases by financial creditor, there should be equal number of, if not more, the personal guarantee cases would be there. However, when we compare it, we'll be surprised to know that only 1839 applications have been filed since then for initiation of personal insolvency resolution process. 170 applications have been filed by debtors and 1669 applications filed by the creditor itself. And kindly see the situation here, these are the creditors, not the financial creditor, not the operational creditor. Any creditor can find where the guarantee has been given. So despite the situation, only 1669 applications are there. And if we see situation further, debtor itself has filed 170 application, creditor have filed 1669 application, total 1839 application. And what is the status of those applications is here. Out of 1839 application which has been withdrawn are 28, number of applications dismissed and rejected are 35, number of cases where RPs have been appointed. As we all know, this is in 3 stages. Firstly, immediately upon appointment, RP is appointed, RP gives the report, then the application is admitted, only then the insolvency resolution process in respect of personal guarantor initiates. So here RP has been appointed only in 760 cases. And out of that, number of applications have withdrawn 11, number of applications dismissed rejected 25. So total admitted cases, that's the second stage, only 208. In comparison to 3,000 applications which are already pending, initiated by the financial creditors. The numbers become more interesting if we go further. The debt amount has been recovered from the personal guarantor is only to the tune of around 1.57% realization. And if we see bankruptcy process, the most interesting point is all of these, only 10 applications are initiated by the creditors under section 123 of the code. So from 6,000 CRP cases, 3,000 filed by the financial creditors, and when we come to the situation of personal guarantors, only 1,800 applications, 760 application RPs have been appointed, and only 10 applications has reached to the bankruptcy stage. So immediately question arises in our mind, if this is the situation, why this particular jurisprudence could not gain momentum, why the process could not be initiated? The straight answer to that is obviously several rounds of litigation. One after the other, there has been litigation, there has been a stay order by the Supreme Court, by the NCLAT, or the NCLT is not proceeding because of the pendency of these issues. Therefore, the procedure could not be proceeded with. Now, first round, to understand that, kindly see personal guarantors are no different than the individuals. Personal guarantors are individuals covered in Part 3. Part 3 of the Insolvency Code. I am not going by the section-wise commentary here because you all know that, you are all expert in this field. So I am straight away coming to a point that before the amendment of 2018, there was only one category under Insolvency and Bankruptcy Code. That is the individual. But in 2018, there was an amendment where subsection E, F and G were inserted and 3 categories were pointed, which you will see in section 2E, that is personal guarantors to corporate debtor. F is partnership firm and proprietorship firm, and G is individuals other than persons referred to in clause E. Now after amending this, government came up with a notification. That notification came on 15th of November 2019, and the notification said, read as under, that in exercise of power conferred by subsection 3 of section 1, the central government hereby appoints the 1st day of December 2019 as the date on which the following provision of said code only insofar as they relate to personal guarantors to corporate debtors shall come into effect. So after amending the definition, Part 3 was made applicable only to the personal guarantors. So as far as individuals are concerned, till date, the sections and as well as the Part 3 has not been notified. Only provision in this regulation, the personal guarantor has been notified. And Since that day also, we are in May 2023, almost 2.5 years. Matter could not be proceeded with. So the first challenge along with these, of course, the regulations or rules and regulations were also framed. The first round of litigation came where legality of this notification was challenged before the Supreme Court. The main ground of legality was the priority on the ground that the power of government under section 1 subsection 3 of the code could not be used to limit the provision of the code to personal guarantors of corporate debtor. Amongst the major point of challenge which was before the Supreme Court was, number one, that the central government could not have selectively brought the code into force and applied the provision to only one subcategory of individuals, that is personal guarantor to the corporate debtor. Because in respect of individuals, Act was not notified, Part 3 was not notified, but in respect of personal guarantors, government itself by notification can it bifurcate between a personal guarantor as well as the individuals. Second contention was central government ought to have brought section 243 into effect. Section 243 repeals the earlier law relating to insolvency of individuals. Those were not repealed. Then liability of personal guarantor post approval of resolution plan, saying that once the resolution plan is already approved, personal guarantor should also be discharged from their liability. And the extent of liability of personal guarantor to corporate debtor, because that has already been recovered through the process of resolution plan. And once that is recovered, you cannot recover the balance amount from the guarantor itself. When this matter, first time, the Supreme Court upheld the constitutionality in the judgment of Lalit Kumar Jain, and it was held, immune notification is not an instance of legislative exercise amounting to impermissible and selectively application of provision of the code. The legislative intent was to treat the personal guarantor differently from other class of individuals as provided in the code. The provisions contained in section 2E, that is what we just read with respect to personal guarantor, section 522, which defines the personal guarantor in part 2, and section 60 and section 179, which we will just discuss, specify the connections of the personal guarantors with corporate debtors so as to enable Honorable NCLT to have holistic approach about the nature of assets available during and post-insolvency process. Further, this would also enable the COC to frame realistic plan keeping in mind the prospect of realization some part of the creditor due from the personal guarantors. Personal guarantors liability does not get discharged upon the approval of resolution plan. Relied upon State Bank of India versus V. Ramakrishna, which is the first judgment where before the amendment itself, Supreme Court has dealt with the provision of section 16 and has held that a holistic approach is required when we are dealing with the resolution plan and the personal assets of the personal guarantors. Section 31(1), which we all know that's binding on all the stakeholders once the resolution plan is approved, mandates that the resolution plan is also binding on the personal guarantor, and thus the resolution plan may include provision of payment by guarantor. Therefore, guarantors cannot escape payments. Liability of the guarantor is coextensive with the corporate debtor. However, the extent of liability will be governed by the underlying agreement. Therefore, finality to the insolvency proceeding per se does not operate as a discharge of the guarantor liability under the contract of guarantee. So after this judgment, everyone assumed now, of course, there is no scope left for the personal guarantors. Now, proceeding will initiate, and the law relating to personal guarantors will gain momentum. But then came the second round of litigation. Again the matter could not be proceeded with. And this is very interesting issue here, where the question was in respect of a jurisdiction. Whether DRT has the jurisdiction in respect of personal guarantors, or NCLT has the jurisdiction to deal with the application filed on behalf of personal guarantor. When we see part 3, section 79, it defines the adjudicating authority for the purpose of part 3 is DRT. So therefore, it is assumed that all applications should be filed before the DRT. But we see the actual scenario, only 10 applications have been filed before DRT. But section 60, which is in part 2, when we deal with the corporate insolvency resolution process, provides an exception to section 79. Now section 60 says, subsection 1, the adjudicating authority in relation to insolvency resolution and liquidation for corporate persons including corporate debtors and personal guarantors thereof, shall be National Company Law Tribunal having territorial jurisdiction over the place where the registered office of the corporate person is located. So section 60 is an exception to 79, providing NCLT as the adjudicating authority for personal guarantor. But interestingly, the challenge came to the provision of section 60 subsection 2. When we read section 60 subsection 2, it says without prejudice to subsection 1 and notwithstanding anything to the contrary contained in the code, where a corporate insolvency resolution process or liquidation process of a corporate debtor is pending before a National Company Law Tribunal, an application relating to insolvency resolution or liquidation or bankruptcy of a corporate guarantor or personal guarantor as the case may be of such corporate debtor shall be filed before such NCLT. So there was an argument on this, that adjudicating authority in respect of personal guarantor shall be NCLT only where the CIRP is already pending before the NCLT. Otherwise, the body will always remain DRT. So all fresh applications are required to be filed before the DRT. Only in a situation where NCLT is already dealing with the situation of insolvency of corporate debtor, such application in respect of individual shall be filed. This has to be read coupled with section 60 subsection 3 and section 60 subsection 4. 3 says the insolvency resolution process or liquidation or bankruptcy proceeding of a corporate guarantor or personal guarantor as the case may be of the corporate debtor pending in any court or tribunal shall stand transferred to adjudicating authority dealing with the insolvency resolution process or liquidation proceeding of such corporate debtor. So if the proceeding has been initiated before the DRT or at any other place, those proceedings shall get transferred to the concerned adjudicating authority, that is NCLT. And 4, given the power. 4 says National Company Law Tribunal shall be vested with all the powers of DRT as contemplated under Part 3 of the Code for the purpose of subsection 2. So NCLT was given the power of DRT. So it was assumed always that DRT definitely has the power. Power has only been conferred upon the NCLT. So, because of this, another challenge was made where when the applications were being filed before the NCLT, several questions arose. What is the meaning of pendency of proceeding before the NCLT in respect of corporate debtor? Whether mere filing of an application will be called as a pendency, or where the resolution plan, whether application has been admitted and resolution plan has not been approved, only that stage will be called pending, or where the resolution plan has already been approved. Can we say that application is still pending before the NCLT? So in respect of the cases where application was already admitted but resolution plan has not been approved, in that stage it was agreed position that yes, only NCLT shall have the jurisdiction, and that's why you see the number of 1839 applications which were filed. That was the only reason the applications were filed and proceeded with. But in respect of other two categories, that is prior to admission of the application and after the resolution plan, because we all know once the resolution plan is approved, the CIRP comes to an end. If CIRP comes to an end, then section 60 subsection 2 may not apply. So therefore a challenge was made where it was contended, correct adjudicating authority for personal guarantor, whether pendency of CIRP against corporate debtor is a mandatory prerequisite for initiating IPR for personal guarantor. Now this issue was firstly discussed in the judgment of V. Ramakrishnan, which we just discussed, where they have only dealt with provision of section 60 subsection 1, saying that where the application is pending, the adjudicating authority shall only be NCLT. The application can be filed before the NCLT and DRT shall not have the jurisdiction, but in respect of other places, the judgment was silent, whether it will be DRT or the NCLT. The Madras High Court had the occasion to deal with this situation in a judgment of Rohit Nath versus KEB Hana Bank, where it was held that provision of section 60 of the code would apply to an individual only if there is a corporate insolvency resolution process that has been filed or commenced pertaining to the corporate entity which is principal debtor. Again, the situation is where the CIRP is going on. The uncertainty pertaining to jurisdiction of NCLT to adjudicate upon the matter of personal guarantor of corporate debtor was finally put to rest in the judgment of State Bank of India versus Mahendra Kumar Joria. So this is the landmark judgment on this issue, where the Honorable Enclave held that subsection 1 of section 60 provides that adjudicating authority for the corporate persons, including corporate debtor and personal guarantor, shall be NCLT. So they have interpreted that section 60 subsection 1 is general section, gives the jurisdiction to NCLT only in respect of all the application. Section 60 subsection 2 is only for the reasons where application is pending before a particular NCLT, only those proceedings shall be transferred. Otherwise, in respect of personal guarantor, it will only be NCLT. There will not be any other adjudicating authority. DRT shall not have the jurisdiction. So it was held the subsection 2 of section 60 required that where a CIRP or a liquidation process of corporate debt is pending before a NCLT, the application relating to CIRP of the corporate debtor or personal guarantor, as the case may be, of such corporate debtor shall be filed before such NCLT. The purpose and object of subsection 2 of section 60 is that when proceedings are pending in a national company law tribunal, any proceeding against the corporate guarantor should also be filed before such NCLT. The idea is that both proceedings be entertained by one and the same NCLT. The subsection 2 of section 60 does not in any way prohibit filing of procedure under section 95 of the code, even if no proceedings are pending before NCLT. The use of the word and such before NCLT clearly indicates that section 60 subsection 2 was applicable only when a CIRP or liquidation proceeding of a corporate debt is pending before NCLT. The object is that when a CIRP or liquidation proceeding of a corporate debt is pending before NCLT, the application relating to insolvency process of a corporate guarantor or personal guarantor should be filed before same NCLT. This was to avoid two different NCLT to take up the CIRP of a corporate guarantor. Section 60 subsection 2 is applicable only when CIRP or liquidation process of a corporate debtor is pending. So it further says, section 60 subsection 2 begins with expression without prejudice to subsection 1. Thus, provision of section 60 subsection 2 are without prejudice to section 60 subsection 1 and are supplementary to subsection 1 of section 16. So ultimately it was held, in view of these provisions, the adjudicating authority will always be NCLT and not be DRT. But of course, in this judgment, they have not dealt with the personal guarantor's rule, where personal guarantor's rule specifically provide that adjudicating authority in respect of other cases than the one which is being dealt with by the NCLT shall be DRT. So even personal guarantor rules envisages a situation filing of an application before the DRT. That was not considered in this judgment. Of course, that is still pending consideration. We have argued this point before Chennai NCLT. Judgment is already reserved. Whether this judgment needs reconsideration in view of the rules of personal guarantor provided. So this was the second round which was ultimately settled in Jijodia case, which has been upheld again by two more judgments of CONCLAVE, where they have also held the same thing, that adjudicating authority in respect of personal guarantor shall always be NCLT. So we assume that situation, now there will be a situation where this process will smoothly function. But again, the third round of litigation came. Now, third round of litigation was in respect of Surendra B. Jivrajika versus Omkar Asset Reconstruction Limited, where the question has arisen that part 3, when we see it deals with the situation where any creditor can file an application, and section 95 says that upon filing an application, the resolution professional be appointed immediately. There is no provision under the code to issue notice to the personal guarantor, giving an opportunity of representation, hearing him, and then passing an order. Therefore, the Supreme Court has seized of this matter, where several petitions are filed, more than 100 petitions are pending, and the question is that there is a violation of natural justice in the process, and therefore these provisions are unconstitutional. Notice has already been issued, and if you see, the basis of these petitions are like here. 95 simply says the creditor may apply either by itself or jointly with the other creditor, or through a resolution professional to the adjudicating authority for initiating an insolvency resolution process under this section by submitting an application. So 2 is in respect of partnership firm. 3 says where an application has been made against one partner, then again it's against partner. 4 is shall be accompanied by the detail and documents. Section 96 provides for interim moratorium, and 97, the moment we see, if the application under section 94 or 95 is filed through a resolution professional, the adjudicating authority shall direct the board within 7 days of the date of application to confirm that there are no disciplinary proceedings pending against the resolution professional. Board shall within 7 days, of course these were the provisions during CRP also, but later on these provisions have been amended, and adjudicating authority now directly can appoint the resolution professional. Therefore, 97, subsection 3 says, where an application under section 94 or 95 is filed by a debtor or a creditor himself, as the case may be, and not through the resolution professional, adjudicating authority shall direct the board within 7 days to nominate a resolution professional for the insolvency resolution process. So, what code envisages is, the moment any creditor files an application, resolution professional immediately shall be appointed. And there will not be any opportunity of hearing to be given to the personal guarantor, though later on clarified, and there is a judgment came where it says that only limited notice is required to be given to the personal guarantors, and once the personal guarantor knows that these proceedings are initiated against him, then immediately RP can be appointed. But the contention before the Supreme Court is very limited to only constitutionality of these provisions and regarding the violation of natural justice, whether in view of these provisions, these sections are constitutionally valid or not. Now the matter is seized off by the Supreme Court, and matter is pending and coming up in July 2023. So we hope that issues will be decided, and after that procedure may begin. Then submission. Then next stage is, of course, section 100 is the stage where the insolvency resolution process begins. We have seen only 270 application has reached to this stage, where resolution professional has filed a report. That report has been considered by the adjudicating authority, and after the consideration, the application has been admitted and the insolvency process begins. And of course, moratorium we are not dealing with today. This is the permanent moratorium which is kicks in once this is done. See, last, the Supreme Court in Acae case has stayed the insolvency proceeding initiated against the personal guarantor. However, no blanket stay has been granted on the operations of the provision of the court with respect to personal guarantor. Initially, similarly placed petitions were being tagged with the lead matter, and an order for stay of respective insolvency proceeding are being granted. However, now the court is merely tagging these matters without staying the insolvency proceeding. The personal guarantor continue to defer the pendency of these batch of the petition before the court for seeking a stay. In view of the pendency of the batch of petition before the Honorable Supreme Court, various NCLTs are either staying the process or simply adjourning the process. So before NCLT principal bench itself, when these petitions are listed, you will see that hundreds of petitions are listed in one go and being adjourned, awaiting the outcome of the Supreme Court order. So once this law will be settled, we'll have to see a situation, and we hope that these provisions, the law related to personal guarantors, shall also proceed with us. Thank you.
Thank you very much, sir. It was really very much enthralling session, and the way you dealt with all these developments and then the settlement of the disputes by the Supreme Court, it was really very, very informative. And now I will request Tarun to give the formal vote of thanks to the learned speaker.
Shri Sandeep Bajaj ji, advocate. Sir, we thank you from the core of our heart for taking out time and sharing your valuable thoughts with us today. So you have made the entire subject of personal guarantors look very easy, although I am sure it's not very easy. You have shown so many rounds of litigations that are happening. It's a new subject, and although I don't practice IBC, but I understand it's also a very touchy subject, because we are entering into the house of a personal guarantors, expenses, income, everything, so it's very touchy, I understand. So the detailed presentation that we have made also, I'm sure will be a big reference for all the members, and for the benefit of our members, I will tell you that we will upload this presentation on our website, so you can download it from there for your future reference. Thank you so much. Please carry this with a big round of applause. So, sir. And now we break the session for lunch. Please join us for lunch. and we will start the next session sharp at 2:30.